New York Judge J. Schecter, embroiled in Defi patent scandal, one of two. The following is a complaint submitted to the NYS Commission on Judicial Conduct, drafted and submitted by the Veri Community. Alleged breaches of Model Code of Conduct by Judge Jennifer Schecter in Hall v. Middleton et al. Case 655003_2019. Contents. Article 1 of 2. 1. Alleged breaches of Model Code of Conduct by Judge Jennifer Schecter in Hall v. Middleton et al. Case 655003-2019. 2. Brief introduction. 3. Model Code of Judicial Conduct, Canon 1. 4. Model Code of Judicial Conduct, Canon 2. 5. Rule 2.15, Responding to Judicial and Lawyer Misconduct. 6. Affirmation of Carl Brundage. 7. Affirmation of Reggie Middleton. 8. Affirmation of Sheridan, England. Article 2 of 2. 1. Rule 2.2, Impartiality and Fairness. 2. Rule 2.3, Bias, Prejudice, and Harassment. 3. Rule 2.4, External Influences on Judicial Conduct. 4. Rule 2.5, Competence, Diligence, and Cooperation. 5. Rule 2.6, Ensuring the Right to be Heard. Brief Introduction. By a letter agreement dated 13th February 2019, Exhibit 1, Carl Brundage Affirmation attached, Sheridan, England became, quote, of counsel, end quote, to the firm of Brundage and Stanger, B&S, patent attorneys as clearly stated on the letterhead, having relevant company commercial litigation expertise and experience to offer to the clients of B&S. It was a reciprocal arrangement which, inter alia, provided for payment terms, specific payment rates for his work from the firm's client, Veritasium. By an action dated 30th August 2019, Hall sued Middleton et al. For essentially the determination of ownership of patents. Unfortunately, the plaintiff's allegations were not properly tested as the defendants were precluded from producing evidence and witnesses and denied the opportunity of challenging the plaintiff's evidence by order of Judge Schecter, due entirely to, quote, office failures, end quote, as subsequently referred to in this submission. Although an answer was filed on 3rd October 2019 by Miss M. Lee, an employee of B&S, and went on record at that point, she received considerable assistance and input from England in drafting and submitting the same, a point the judge failed to appreciate, perhaps due to an oversight. Due to, quote, office failures, end quote, crucial deadlines were not met, entirely down to England's failure to file, denying the defendant, Middleton, to properly present his case, and as such was denied due process, a breach of his constitutional rights, which the judge had sworn on oath to uphold. It is clear from Brundage's and Middleton's affirmations attached that England had deliberately and intentionally failed to make the appropriate filings, but that he did so without the permission nor knowledge of B&S and Middleton. Indeed, when the affirmation of Brundage is closely examined, England had falsely represented that he had indeed, quote, satisfied, end quote, the order. England then files a motion to be withdrawn from the case, see England's affirmation attached, wherein he complains about alleged non-payment of fees, for which no evidence was provided, and completely contradicted by the affirmations of Brundage and Middleton. Furthermore, Exhibit 2 to Brundage's affirmation shows an attempt to pay for pretrial and trial work, requesting England to provide a figure. The non-payment of fees by a client was a spurious argument in that Middleton was not the client of England, but the client of B&S, and B&S were responsible for payment of England's fees. Unbeknown to the judge, a special arrangement had been made between Brundage and Middleton, whereby B&S would cover of counsel fees to England through the potential recovery of substantial damages on a separate contingency case concerning patent infringement. Further inquiry by the court would no doubt have revealed this. The judge allowed England to withdraw from the case, improperly in our view, and without disciplining him for his ethical misconduct. With respect, we believe the judge erred in that she allowed England to withdraw, arguing that Middleton already had representation through Miss Lee because she had filed an answer and a letter on behalf of Middleton, However, the judge overlooked the fact that England had largely drafted the answer, and the whole raison d'etre for England's appointment of counsel was because B&S were patent attorneys and did not have the relevant expertise and experience with company commercial litigation matters. Had she properly considered the situation, the judge should have either ordered England to remain, or in view of the admitted lack of his capabilities in his own affirmation, she should have given time for Middleton to find alternative suitable qualified representation, so as to not harm his position, and that justice could be done and be seen to be done. Model Code of Judicial Conduct, Canon 1. A judge shall uphold and promote the independence, integrity, and impartiality of the judiciary, and shall avoid impropriety and the appearance of impropriety. The contents of the following are intended to paint a broad picture of the Hall v. Middleton et al. Case, but fuller and more specific details appear in the following alleged breaches contained within Canon 2 below. Definition of judicial corruption. Under New York law, judicial corruption involves actions taken by a judge that are 1. Illegal or unethical, violating legal or ethical standards purposefully. 2. Improper and prejudicial, engaging in behavior that unjustly disadvantages one party. 3. For personal gain or under undue influence, acting with motivations of personal benefit or external pressures. Elements of alleged corruption in Judge Schecter's actions. 1. Intentional wrongdoing. Preclusion without just cause. Judge Schecter precluded Middleton's evidence, defense witnesses, and denied Middleton of the ability to question the plaintiff's evidence based on procedural noncompliance, attributed entirely down to his former attorney's, quote, office failures, end quote. Such harsh sanctions without clear evidence of willful and contumacious noncompliance by Middleton imply an arbitrary and unfair judicial process. These sanctions disproportionately harm Middleton's defense, indicating an underlying bias, a lack of just cause, and improper intentions. 2. Improper and prejudicial conduct. Corroborated and uncontested testimonies overlooked. Affirmations from Reggie Middleton, Carl Brundage, and Sheridan England attached consistently prove that Middleton was not informed of critical court deadlines by England. The judge ignored these testimonies without substantiating her decision with countervailing evidence. Judge Schecter dismissed these corroborated testimonies, which undermines the trustworthiness and impartiality expected of a judge. Ignoring substantial evidence questions the integrity and fairness of the judicial process. 3. Personal gain or undue influence. SEC allegations and consent orders utilized wrongfully. The judge employed non-evidentiary sources such as SEC allegations and consent orders, which did not admit wrongdoing, to support excessive punitive damage awards. The judge stated, quote, punitive damages of similar magnitude are warranted here, end quote. These actions were instrumental in unduly prejudicing Middleton by relying on hearsay and external allegations. Utilizing such sources signals potential bias or undue influence, as it has deviated significantly from relying on trial evidence and sound judicial practices. 4. Comparison of disparate treatment. Inconsistent handling of procedural violations. Judge Schecter severely penalized Middleton for procedural missteps while often allowing similar errors by Charles Hall to go unpunished. For example, the return dates favoring the plaintiff, carte blanche, acceptance of the plaintiff's late filings, and dismissal of the defendant's legitimate motions characterize an imbalanced judicial approach. This inconsistent application of rules underscores preferential treatment towards the plaintiff. The fairness mandated by judicial conduct rules is thus breached, indicating improper judicial behavior motivated by bias or external pressures. 5. Additional supporting evidence. Judge's language and prejudice comments. Judge Schecter's harsh terminology towards Middleton versus more favorable treatment of Hall suggests an unbalanced and prejudiced mindset. This inequitable vernacular undermines judicial neutrality and fairness. 6. Taking personal assets. Legal standard. Judicial decisions involving personal assets must be fair and based on sound legal principles. Judge Schecter's decision to place Middleton's patents into a company with no assets to defend them, despite knowing they were under attack, indicates a potential abuse of power. This action disregarded the security of Middleton's personal assets and the company's ability to defend its intellectual property. 7. Economic liability on the company. Legal standard. In derivative shareholder actions, the best interests of the shareholders must be paramount. Imposing a $450,000 attorney fee judgment on a company unable to pay and providing a $1 million punitive damage award without considering Middleton's ability to pay shows disregard for the company's financial health and shareholder interests. This creates an unfunded liability, undermining the company's viability. 8. Ignoring pleas of inability to pay. Legal standard. Judges must consider all relevant factors, including the financial capacity of individuals and entities affected by their rulings. By ignoring Middleton's pleas about his inability to pay the punitive award, Judge Schecter demonstrated a lack of consideration for critical financial information. This action could be seen as prejudicial and improper. 9. Constructive trust attempt. Legal standard. Judicial actions must prevent unjust enrichment and ensure fair proceedings. Knowing that the plaintiff sought to take patents through a constructive trust, the judge's decisions favored the plaintiff's strategy without adequate safeguards for Middleton's interest, indicating potential bias and improper conduct. Further evidence of corruption elements. Judge Schecter's handling of the case involving Reggie Middleton raises substantial concerns regarding the impartial evaluation of testimonies. Notably, the judge consistently dismissed Middleton's credibility without thoroughly considering corroborated and uncontested evidence. This analysis examines the transcripts, affirmations, letters, and depositions to demonstrate the discrepancies between the judgment's assessments and the actual records. 1. Detailed examination of testimonies and evidence. Judge's dismissal of Middleton's testimony. Judge Schecter dismissed Reggie Middleton's testimony as, quote, baseless, end quote, and his procedural applications as, quote, frivolous delay tactics, end quote, despite no substantial evidence of inconsistency or dishonesty in Middleton's statements. 2. Inconsistency in Charles Hall's testimony. Contradictions and discrepancies. Hall exhibited numerous inconsistencies in his testimony, notably about his role concerning VeriDAO, marketing efforts, and how investment decisions were influenced by the video evidence. Despite these evident contradictions, Judge Schecter did not emphasize or critique Hall's inconsistencies as she did with Middleton's consistent testimony. 3. Judge's language and prejudicial comments. Use of disparaging terms. Judge Schecter criticized Middleton's defense using terms like, quote, revisionist history, end quote, and accused him of, quote, throwing Mr. England under the bus, end quote, and described his conduct as, quote, willful violation, contumacious conduct, and egregious, end quote, showcasing a hostile attitude. Impartiality issues. Contrarily, the rulings and remarks regarding Charles Hall painted a picture of neutrality and credibility, even while the evidence pointed towards frequent inconsistencies in Hall's testimony. 4. Procedural fairness and judicial conduct. Ignoring substantial evidence. The judge's dismissal of substantiated and uncontested affirmations provided by Middleton without thorough investigation significantly undermines judicial fairness. Such an approach violates judicial conduct rules requiring due diligence and impartial assessment of all evidence. Case law and supporting judicial conduct rules. 1. Judicial conduct and discipline (NY Judiciary Law 44). Judges must avoid impropriety and the appearance of impropriety. Judge Schecter's actions exhibit clear favoritism towards the plaintiff and disregard for an impartial process. 2. Case law. Matter of Greenfield, 76 NY 2D 293, 1990. Summary. Judges are obligated to report attorney misconduct. Judge Schecter failed to act on clear indications of misconduct by Middleton's attorneys and England and Lee, challenging her fulfillment of this duty. Matter of Sims 61 AD 3D1, 1st Department 2009. Summary. Ensuring compliance with professional conduct standards is paramount. The judge ignoring documented attorney failures aligns with a neglect of her supervisory responsibilities. Matter of Schiff 23 NY 3D 32, 2014, and matter of Duckman 92 NY 2D 141, bracket 1998. Summary. It is a responsibility of judges to maintain the integrity of the legal profession by addressing attorney misconduct. Judge Schecter's inaction against clear misconduct on the part of England failed to preserve judicial process integrity. Ordering of return dates favoring the plaintiff. 1. Pattern of favoritism in setting motion practice return dates. Example 1. Document. Stipulation adjourning the motion for contempt filed by plaintiff Charles Hall. Details. The return date for the plaintiff's motion for contempt, initially set for June 15, 2023, was adjourned to July 14, 2023, and then further adjourned to August 25, 2023. The multiple adjournments granted to the plaintiff allowed greater flexibility and preparation time for the plaintiff while restraining the defendant Middleton's ability to respond effectively. 2. Multiple instances allowing plaintiff's late motions and filings. Example 2. Document. Court order details related to Charles Hall's filings. Details. On several occasions, the court accommodated late filings and extensions for the plaintiff without similarly extending such courtesies to the defendant. A pattern of accepting the plaintiff's late filings while strictly penalizing the defendant for similar procedural lapses indicates preferential treatment. 3. Denied requests by defendant for extensions or introduction of evidence. Example 3. Document. Transcripts and court orders regarding denied motions from Reggie Middleton. Details. Requests for extensions and introduction of evidence by Middleton were repeatedly denied, often characterized dismissively as, quote, non-compliant, end quote, or, quote, delayed, end quote. The stark contrast in treatment, granting plaintiff's adjournment requests while denying the defendant's similar request, demonstrates procedural bias and inconsistency. This biased handling undermines procedural fairness required by judicial codes. Violation of judicial codes and procedural fairness. Requirement of impartiality. Judicial codes mandate fairness and impartiality in procedural settings and decision-making. Setting return dates that unreasonably favor one party over another circumvents these ethical standards. Impact on case fairness. The consistent pattern of favoring the plaintiff's procedural requests while denying similar requests from the defendant disadvantages the defendant in preparing and arguing their case. This impairs the defendant's right to a fair trial. Comparative disadvantages. Imbalanced preparation time. Favoring adjournments for the plaintiff quantifiably extends their preparation time while compressing or denying the defendant's time to respond. This asymmetry in preparation time can critically affect the quality of the defense and the overall balance of the trial. Denial of equitable relief. These actions deny the defendant equitable relief typically available under similar circumstances, pointing towards a prejudiced procedural conduct from the court. Conclusion. Based on Judge Schecter's demonstrated bias, improper conduct, and failure to uphold judicial standards, there stands a substantial case for judicial corruption. The documented actions indicate illegal or unethical behavior, purposefully dismissing crucial evidence and testimonies, improper conduct, favoring one party and undermining due process, undue influence, prejudicial reliance on unrelated SEC allegations. Judge Schecter's actions reveal a discrepancy between her stringent assessment of Middleton's credibility and the lenient treatment of Hall's inconsistencies. By systematically devaluing consistent and substantiated testimonies provided by Middleton while overlooking the numerous contradictions in Hall's account, the judge's impartiality is called into question. This analysis supports the assertion that Judge Schecter's handling of the case was biased, and her credibility assessments were unjustified. Judge Schecter's actions in this case exhibit elements of judicial corruption, including purposeful illegal actions that were improper and prejudicial. Her decisions disadvantaged Middleton by ignoring corroborated evidence, imposing severe sanctions without just cause, favoring one party over another, and utilizing hearsay to justify punitive damages. These actions collectively undermine the fairness and integrity of the judicial process, and given the extensive evidence of bias and improper conduct, a strong valid argument for corruption against Judge Schecter can indeed be made. The documented instances of prejudicial actions and failure to adhere to judicial standards highlight the need for rigorous evaluation by judicial oversight authorities. Model Code of Judicial Conduct, Canon 2. Rule 2.15. Responding to judicial and lawyer misconduct. B. A judge having knowledge that a lawyer has committed a violation of the rules of professional conduct that raises a substantial question regarding the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects shall inform the appropriate authority. The contents of this section are equally repeated in their entirety insofar as they are appropriate for Rule 2.2, Rule 2.3, Rule 2.5, and Rule 2.6 above. Analysis of court clerk's knowledge and of judge's responsibility. Paragraph 24 of Carl Brundage's affirmation. Quote, on February 16, 2022, I received a frantic call from Sheridan explaining that he was very upset with being questioned regarding ethical violations by the clerk conducting the February 16, 2022 hearing. I asked Sheridan why he was being questioned in the manner and what happened. Sheridan then explained that he did not conduct the required filings on November 17, 2021 and February 1, 2022. End quote. 1. Rule of Court Clerk. Court clerks play a crucial role in managing the procedural aspects of court cases. They are responsible for ensuring that all filings and court orders are properly recorded and communicated to relevant parties. In cases where ethical violations are suspected, clerks typically bring these issues to the attention of the judge or hired court officials. 2. Imputation of knowledge. Constructive knowledge. Legal doctrine often imputes knowledge of the clerks to the judge, especially when the information pertains to procedural or ethical violations. This is because clerks act as agents of the court, and their knowledge is considered to be within the scope of the judge's oversight responsibility. Duty to act. If a court clerk is aware of significant procedural violations or ethical misconduct, the judge has a duty to investigate and take appropriate action. Ignorance of the clerk's knowledge is generally not a defense for the judge, especially if the matter is serious and affects the fairness of judicial process. 3. Specific case context. In the case of Charles Hall versus Reggie Middleton et al., the court clerk, Mr. Rand, was aware of the ethical violation committed by Sheridan England as evidenced by Brundage's affirmation. Given the severity of the allegations, failure to file critical documents, it is reasonable to assert that the clerk's knowledge should have been communicated to the judge, and the judge should have been aware of the situation. 4. Judge's responsibility. Model Code of Judicial Conduct requires judges to perform their duties impartially and diligently. This includes taking appropriate action when informed of potential ethical violations by attorneys. Failure to act. If Judge Schecter did not take action after being aware, or should have been aware, of ethical violations by Sheridan England, it constitutes a failure to uphold judicial standards. This failure undermines the fairness of the judicial process and the due process rights of the defendant. Exhibit 3 to Carl Brundage affirmation. Exhibit 3 contains various correspondence between England and the plaintiff's lawyers, Troy Fodderman and the firm of Ford Marin, and the court's clerk, Mr. Michael Rand. The first section contains emails dated 7th October 2021, followed by a letter, partly redacted, dated 10th August 2021, and then a further set of emails, dates ranging from 24th March 2020 to 26th of June 2020. The contents of this exhibit were retrieved from England's case file, following his withdrawal, and Carl Brundage, in his affirmation, expresses complete surprise with this correspondence, as he had absolutely no knowledge of the same. On the face, the emails look fairly innocuous, but you will recall that England was of counsel to BNS and should have been using both the email domain that had been provided by BNS, as well as using their letterhead concerning any letter correspondence on behalf of BNS clients, as in this case. By using his own firm's email address and his own firm's letterhead for correspondence raises serious issues of potential conflict of loyalty, since this would have been hidden from BNS and the client, Middleton et al. The next set of emails with earlier dates are even more concerning, since they are between England, on his own firm's email domain, with opposition counsel and the court's clerk, Mr. Michael Rand. You will note that the communications were made concerning the next procedural steps in the proceedings to various email addresses, but not including Miss Lee of BNS, nor BNS. That is, the court's clerk was emailing procedural steps for the case but did not include any notification to the other counsel of record, Miss M. Lee, on behalf of the defendant, Middleton. This is highly unusual since the judge relied on the fact that Middleton had counsel to continue to represent him, hence why she allowed England to withdraw. It is unlikely that Mr. Rand would have issued separate notifications to Miss Emily, as this would have been too cumbersome to manage. If Miss Emily was on the record, then she should have also received notifications of any procedural steps, and since it is clear that she was not included in these various email threads, the assumption must mean that she was inadvertently removed or excluded from record. This provides confirmation that Miss Emily and BNS did not receive all communications and notifications from the court. Since Mr. Rand knew that Miss Emily was not receiving such notifications, then the judge knew or should have known, on the basis of implied or imputed knowledge or constructive knowledge, meaning she should have not allowed the withdrawal of England or at least given time for Middleton to have sought suitable alternative representation. Conclusion. Based on the legal framework and the context provided in the affirmation, it is reasonable to conclude that the knowledge of the court clerk regarding the ethical violations by England should be imputed to Judge Schecter. The judge's failure to act on this information, despite the severity of the violations, represents a significant lapse in judicial responsibility. Furthermore, the knowledge of the court clerk that Miss Emily and BNS were not included in all court communications must also be implied or imputed to the judge, and therefore should not have allowed England to withdraw or allowed Middleton to seek alternative suitable qualified counsel. This was an error or oversight on the part of the judge. Whereas it is accepted that the whole raison d'etre of this court is to expedite company commercial disputes, such a dogged pursuit should not be so strictly followed where it may lead to grave injustices as it has done in this case. Judges' role in addressing violations of professional conduct. Rule. A judge who receives information indicating a substantial likelihood that a lawyer has committed a substantial violation of the rules of professional conduct 22 NYCRR Part 1200 shall take appropriate action. The judge's failure to address potential violations of professional conduct by Middleton's attorney display clear indications of such violations could be seen as neglecting her disciplinary responsibilities. Case Law 1. Matter of Greenfield 76 NY 2D 293 1990. This case emphasizes the duty of judges to report attorney misconduct when they become aware of actions that may constitute a violation of professional conduct rules. 2. Matter of Sims 61 AD 3D 1 First Department 2009. This case discusses the obligations of judges to ensure that attorneys appearing before them adhere to professional conduct standards and to take action when violations are observed. 3. Matter of Schiff 23 NY 3D 32 2014. This case highlights the importance of judicial oversight in maintaining the integrity of the legal profession by addressing attorneys' misconduct. 4. Matter of Duckman 92 NY 2D 141 1998. This case underscores the responsibility of judges to report and address attorney misconduct to preserve the integrity of the judicial process. 5. Matter of Kavanaugh 38 AD 3D1 First Department 2006. This case discusses the duty of judges to ensure that attorneys comply with professional conduct rules and to take corrective actions when necessary. Word count has limited the ability to present this complaint in full, so it's been broken up into two parts. Continued in Article 2 is the Rule 2.2, Impartiality and Fairness, Rule 2.3, Bias, Prejudice, and Harassment, Rule 2.4, External Influences on Judicial Conduct, Rule 2.5, Competence, Diligence, and Cooperation, Rule 2.6, Ensuring the Right to be Heard. Also included in Article 1 is the affirmation in opposition to the order to show cause by Carl Brundage, the affirmation in opposition to the order to show cause by Reggie Middleton, the affirmation of Sheridan England, the affirmation in response of Sheridan England, and a link to a folder containing the full complaint, affirmations, and exhibits, along with instructions on how to file a complaint. A link to this article will be linked below in the description. Thank you.